I'm very pleased to be asked to do this by Derry City and Strabane District Council in association with the Enterprise Week, which has been going on all week. Thank you to Danielle and Evan from the council who came on with me this morning and sorted out a few technical hitches. As I said, much prefer to be doing this in person. Hopefully in the future we'll get to the stage where that becomes the norm again. But for now, it is what it is, and we're doing these by webinar most of the week, I think, for most of the presentations. So I suppose what the talk today is about is restrictive covenants, and we're particularly looking at protecting IP, your staff and customer lists. So when I was asked to do this originally, it would have been very easy for us from a particularly employment law angle to do this on something that we kind of use more on a day-to-day basis that we can roll off the tongue. Restrictive covenants isn't something that you deal with on a day-to-day basis. It doesn't come up very often in employment law and in law. However, over the past year, it has come up an exceptionally increasing quantities because of, I suppose, what they call the great resignation following the pandemic, with people moving jobs and moving across to new employers and new positions. There has been a massive push on the restrictive covenants because businesses are concerned about their own confidentiality, their clients and their own business moving forward. So increasingly over the last 12 months, we have been asked to review restrictive covenants. And in the main, restrictive covenants that I have reviewed have been unenforceable. My advice to the employer has been that the covenants are not enforceable and that they wouldn't stand up under scrutiny in any court. So when we're asked to do this, I thought that restrictive covenants would be the best topic. It is a very wide and technical area, therefore it's not possible to cover it all in an hour. So what I've tried to do is give an overview and look at explaining what the covenants are, and then looking at what factors affect enforceability, and then looking at potential remedies. But as I say, this will not be a rundown of all of the law on restrictive covenants, because to be honest, you probably need a full day, if not more on that. So first, I suppose a wee bit about ourselves in terms of, it's always good to know who's giving you the information, whether you can trust it or not. So I have been a solicitor now for, I think 12, 13 years qualified. I was educated at Leeds University, Red Law, Leeds University and Queen's University in Belfast. I then completed the legal practice course at Manchester Metropolitan University, and I trained with a large commercial practice in Manchester called JMW. So by way of comparison, JMW would have around 500 staff, and the largest practice in Northern Ireland probably only have around 100, so it's sort of 5 times bigger than anything we have here. In 2010, I joined Solicitors in Belfast in the employment department. And I left there in 2015 and set up McCay Solicitors here in Derry as a niche employment law firm initially. And since then, we've grown into other areas, and I have 10 staff across 2 sites, and in the next 12 months, we should be up to 16 or 17 staff across 3 sites. So I suppose for the last 12, 13 years, I've predominantly been an employment lawyer, albeit that over the last maybe 4 or 5 years, I've been doing a lot of commercial law as well. But my main bread and butter is in employment law. So suppose first off, if we look at what is a restrictive covenant. So a restrictive covenant is essentially a contractual promise where a party undertakes to refrain from doing something to another party. And quite often you'll see these in a bonus scheme, long-term incentive plans, share purchase agreements, or business purchase agreements. and employment contracts. So we'll be focusing mainly on employment contracts today, but the principles are very similar for these other documents as well. And in bonus schemes and long-term incentive plans, essentially what happens there is that remuneration is held back and is contingent upon people remaining employees or and then complying with the covenants. So they're called atypical restrictive covenants. But as I say, for today's purposes, we'll be focusing mainly on employment contracts because that's the one really at the minute that comes up a lot. However, they do intertwine as well with share purchase agreements, where someone would buy a business and say, well, if I buy a business, I expect that the seller, will not set up in competition for a period of X years. So in terms of the restrictive covenants, it has become customary for employers to impose restrictions on activities that the employees can do during the employment and following its termination. So the main counter to that is the doctrine of restraint of trade. So essentially where any contractual restriction on employees' activity, where it prevents them from working, then generally these types of restrictions are void and unenforceable unless the employer can show that there's legitimate proprietary interest, and we'll come on to what that is. It requires protection, and that the protection is no more than what is reasonable in the circumstances, and that is looking at the party's interest and also the public interest test as well. And again, we'll cover these as we go forward. So why does people want to impose post-termination restrictive covenants? So in contracts, there's obviously the express terms within a contract, but there's also implied terms. So there's implied terms of trust and confidence and fidelity between parties. But generally, these types of obligations only apply during the term of the contract, so the term of the employment relationship. But restrictive covenants, if properly drafted, can bind an employee after they leave their employment. And the main thing is that employees who leave, they're often well placed to take advantage of confidential information, of strategic business plans, customer and client details, or other information about the employer's business, and use that after the termination of their employment. So they can use it for the benefit of their new employer, or essentially they can set up themselves as a rival business. And as you can appreciate, this would have massive impact on their former employer's business. So as I said, the benefit of having the express restrictions rather than relying on implied restrictions is that they can be specifically designed to reflect the party's circumstances, and in fact, to be enforceable, they have to be specifically designed. If properly drafted, they can limit the employee's conduct and prevent them from damaging the former employer's business. They may also deter employees from joining competitors at all. And they can also deter potential new employers, because it is possible to add new employers to proceedings against ex-employees, and that is a claim in tort. And there also can be one of the claims is called an inducing a breach of contract, and the other one is called conspiracy, and we'll also look at those at the end. So the key principles, I suppose, for restrictive covenants and enforceability, the court will look at the following key principles in assessing and enforcing post-termination restrictive covenants. So the first one is a legitimate interest. So to be enforceable, a restrictive covenant must be designed to protect a legitimate proprietary interest of the employer, for which the restraint is reasonably necessary. So essentially, the legitimate interests include the employer's trade connections with customers and suppliers, confidential information, and maintaining the stability of the workforce. And we'll actually look at those three issues in turn, because they are I suppose, the first hurdle that needs to be identified and overcome by someone trying to enforce these restrictions. The next one is reasonableness. So post-termination restrictions are enforceable if they're reasonable. And this is really having regards to the interest of the parties and the public interest. So the question of reasonableness has to be considered at the point that the restrictions are entered into, so not the point that you're actually trying to enforce them. So it's were they reasonable at the time that the parties signed them. So essentially when employment was offered and signed up to at the beginning. So there is a special treatment for employment contracts. So restrictive covenants in employment contracts will be looked at, I suppose, more harshly than other documents, because if you think about it, an employee in an employment situation, there's an inequality of I suppose, an inequality of their positions in terms of and their bargaining power, because an employee doesn't really have a lot of scope to negotiate all the terms of their employment. If they're reasonably senior and they're being headhunted, perhaps they do, but generally it's accepted that they're not on an equal footing. So it's therefore less likely that they'll be reasonable. So the next one then is preventing competition. Essentially, a clause can't have the sole purpose of preventing competition. They're never upheld by the court. A non-competition restriction must be designed to protect the employer's confidential information, their trade secrets, or customer connections, so essentially the legitimate interests, and to try and prevent the employee from having an unfair advantage. So non-solicitation clauses are essentially looked at more favorably than what a non-compete clause would be. And we will look at non-solicitation clauses in a minute as well. And we'll look at non-competition clauses, and I'll explain what the differences between them are and why one is more enforceable than the other. The next point is essentially that restrictions must be no wider than necessary. And the famous quote is that it must afford no more than adequate protection to the benefit of the party in favor of who it is imposed. And that's a quote from a case in 1916, and it still rings true today, and the law hasn't really moved on from that. And that is something that we look at in terms of geographical reach and the duration of restrictions, and to ensure that they are no wider than what is necessary in the circumstances. And then severability. So severability is a possibility provided certain criteria are met. Severability is essentially where the court will, I suppose, look at they won't redraft the clause, but they may take certain words out of it if it makes a clause that would be otherwise unenforceable enforceable. But it's quite dangerous for an employer to rely on this, because essentially what would often happen is the court may make the change, but they may hold the employer liable for all of the costs, because it is, after all, their drafting that has made the mistake in the first place. And this is one reason why I think if you have employees that you really are concerned about, the restrictive covenant should be customized and drafted by a lawyer. So what is a legitimate interest? So an employer cannot impose a covenant simply because it does not want an ex-employee to compete with it. It can prevent the individual from using or damaging something that legitimately belongs to the employer. And to determine which rights require protection, the employer must look at the nature of its own business and the nature of the employee's position in the business. So in broad terms, the rights that the court will allow to be protected fall into the following categories. As we said in the first slide, trade connections. So that's with customers, clients, or suppliers, and more generally goodwill, trade secrets and other confidential information, and the stability of the workforce. Arguably, trade secrets are always protectable moving forward without a restrictive covenant anyway, but for a belt and braces approach, you would have it in there. So the trade secrets that people always refer to as, like, the recipe for KFC's gravy and chicken, they would be held as trade secrets, the actual ingredients of how they're made up. So within those types of companies, the likes of Kellogg's as well for their cereals, there only will be a very small amount of people who are actually privy to the recipe that makes up those. And that would generally be held to be protectable moving forward in any event. And a restriction against a person such as that will often be held to be reasonable, whereas a restriction against the person who makes the actual product may not be upheld because they may not actually know how it's made. They just know that they have a part in the process. So the value of their information is limited. So restrictive covenants, they'll also often include introductory wording. And this sets out the interest that the employer is seeking to protect. So effectively the reasons the employer needs the protection from the covenants. This wording needs to be carefully drafted, as covenants will be interpreted in line with the interests it sets out, and the employer will not be entitled to rely on an additional interest at a later stage. As I say there, the drafting is really key in this, and that is quite often where a restriction will fall down. The first paragraph in any restriction should be customized. It should be customized between the role of the employee and the role of the employer. So it should set out what exactly the purpose of the covenant is. What is it that the employer is trying to protect? For the likes of Kellogg's, their restrictive covenant may be that the employee knows the ingredients for how we make cornflakes, and if this ingredients was put into the hands of our competitors, they could replicate exactly what we produce, and that should apply across the board. If you've got someone who's a regional sales director, you may say this person has been dealing with our customers for exceptionally long length of time, and is a very senior individual, knows our pricing, etc., etc. Therefore, both parties have agreed that the covenant is reasonable. And this is quite often where they fall down because they're off-the-shelf covenants and they're not focused enough. So the connection with customers, client, and suppliers. So an employer is entitled to protect its relationship with the customers, clients, and other trade connections. So it was also held in one case that a recruitment agency's pool of temporary workers was held to be capable of amounting to trade connection worthy of protection as well. So that would be very specific to the recruitment industry. The courts have recognized that employees may build up close relationships with such people and gain their trust. They then may look to seek to take advantage of these relationships in a subsequent role, even though the trade connections belong to the employer. In some cases, the customer, client, or supplier may want to continue dealing with the familiar contact, and so will follow them without any encouragement or solicitation by the employee. And that's where sometimes the difficulty arises, because when an employee leaves, the customer may follow the employee to the new employer without any contact whatsoever. And the only way that this can be protected is by way of a non-solicitation or a non-dealing covenant, or in some cases by means of a non-compete covenant. So in the word there, we said that non-compete covenants are not enforceable, but they're not enforceable where the sole aim is to stop competition. So where they're put in as part of an overall covenant where there's non-dealing and non-solicitation included, then they can be held to be enforceable. But this is always subject to the point that the protection has been no wider than is reasonably possible to protect the legitimate interest. So trade secrets and confidential information. Most employment contracts will contain restrictions on using or disclosing confidential information after termination. However, the courts have recognized that this may not provide adequate protection in itself, and that a covenant curbing the employee's ability to work for a competitor may be the only practical way of safeguarding information. And we'll look at some cases where that was held to be the case later on in the presentation as well. So an employee can therefore legitimately use restrictive covenants to protect its confidential information from being used for the benefit of a competitor. However, the employer must demonstrate that the information is genuinely confidential information or amounts to a trade secret. In particular, employers should distinguish between confidential information that may be regarded as the employer's property and skills and experience and know-how that an employee has acquired during the course of their employment. And that's a tricky one, because it's very difficult to say that something that is in the employee's own knowledge belongs to the employer. And it's a very fine line, and you can see evidentially how difficult that would be, where you've got someone who's been doing a job for 20 years, and essentially, the courts won't prevent the employees from using that type of information, even if it is useful to a competitor, because if it's information and skills that they've built up, as a general rule, people are entitled to use their skills to earn a living. The employer, I suppose, has to try and get over the hurdle of proving that no, it's not, it's their confidential information that relates to their processes, to their manufacturing processes, to their products and to their clients. So the next one that we referred to as well was the stability of the workforce. So this concept, I suppose, has developed a lot, and this is one where over time we've seen with the likes of team moves, etc. So the court recognized in the case of Donny Day versus Dolphin that an employer has a legitimate interest in maintaining a stable, trained workforce, and that this may warrant protection through restrictive covenants. So essentially, this is where a departing employee encourages other members of the team to join them in moving to a competitor, and this is known as a team move. It's not something I think that happens very often in Northern Ireland, but in the legal profession, it happens quite a lot, and it happens in big firms in England. So you would actually see in firm A, where the whole property department moves from firm A to firm B, and essentially what happens is that whoever's at the top of the tree in that scenario, in that department, is headhunted, and firm B says, "Look, can you bring the rest of your team?" And then he speaks to the rest of his team, and they all move together, and that's called a team move. And you can appreciate the damage that would do to any employer. So what the employer would look to rely on there is a non-poaching or non-employment restrictive covenants, and we will look at some examples of that as well as we move forward through the presentation. So reasonable protection: if it's a legitimate interest to protect, the employer should only impose a restriction that's no wider than reasonably necessary. So this means limited to the restricted activities that the employee undertook, and also for a period and a geographical restriction as well. Failure to do this is likely to make the covenant treated as void, as it's going to be too wide in scope. In effect, the test of reasonableness requires a balancing exercise to be carried out between the interests of the employer's business, such as goodwill, confidential information, trade secrets, and trade connections, and the individual's right to freedom of movement and to earn a living. So there's been various general principles developed as to how the courts will apply this reasonableness test to restrictive covenants in contracts of employment. So contracts of employment, as I said earlier, the courts will be not as keen to enforce restrictions within a employment contract, and it is because of the relative inequality of the bargaining positions. So they're more happier to impose them with share purchase agreements, joint venture agreements, but the court will look at the parties' individual circumstances. So some of the factors that are relevant is, in particular, how senior the employee is, the status, and quite often the fact that they were involved in negotiating the wording of the covenants at the time that they entered into. So I suppose the court would be more comfortable with a covenant that has had input from the employee, and and has said, junior employees where there's restrictions in their contracts are less likely to go back to the employer and say, actually, I want this amended. Whereas senior employees coming in will be more alive to these issues and will be in a better footing to say to the employer, well, I'm not accepting that restriction. I would like it limited to 6 months, or I'd like it limited to County Derry, County Armagh, wherever it is. So a good example of this was the case of Thomas Farr PLC and another. And in this case, the Court of Appeal upheld a 12-month non-compete restriction in a managing director's contract. It was relevant that as managing director, the defendant employee had been privy to all major and strategic operational decisions made by the employer and had overall responsibility for all of the company's existing business. So you can see in that case that the legitimate interest was quite clear, and that the employee in this situation could create serious problems for the employer, and therefore it was reasonable to impose the 12-month restriction. So in relation to the assessment of reasonableness, so reasonableness is assessed on a case-by-case basis. And that is why it's extremely difficult for us to advise quite often in these scenarios, because there is no one size fits all, and there is no knockout punches. Quite often the court will look at each case and look at the actual specific circumstances and the positions of and qualifications of each party. So in order to be reasonable, the covenant should be tailored to the specific employee and the business in which they operate. And again, that's the problem with off-the-shelf restrictive covenants. Quite often, they will not be enforceable. It is a matter of someone sitting down and looking at each employee and determining what level of protection is reasonably necessary in each case. So what's appropriate for one individual is clearly not appropriate for another. For example, a senior employee may have more involvement and knowledge of the employer's affairs than a low-ranking employee, or two employees on the same level may have different influences over the customers and have a varying knowledge of confidential information. The fact that the employer distinguishes between two employees on the same level may help to persuade the court that it is genuinely and reasonably sought to protect its interests. I think on that point, it is a good point, because you quite often see that a company at setup are provided with contracts of employment, staff handbook, and all you may have junior and senior contracts. Quite often, restrictive covenants will only be in the senior contracts, and the employer, just basically gives out the same contract with the same clauses to every single employee. If a matter came to court, the court would much rather see that the person that we're trying to enforce upon is perhaps the only person who's got these types of covenants, because they've been scoped for him. If the employee makes the defense, actually they weren't, these have been scattered, gone right across everyone, and that I think would also affect enforceability. It wouldn't make it unenforceable, but it certainly would be a matter that would be taken into account, because essentially the burden is on the employer to demonstrate the validity of the covenants, and the employer will have to be able to show why a particular covenant provides adequate protection, but then that it goes no further than is necessary to protect its legitimate interest. So one of the probably the main authority now for setting out the court's approach to reasonableness is TFS derivatives versus Morgan, and this was a High Court case. So the court must first decide what the covenant means when properly construed. So that's essentially take it apart, take apart the wording and work out in plain terms what is the covenant saying that the employee may not do. And then they will consider whether the employer has shown that it has a legitimate business interest requiring protection in relation to the employee's employment. We've already covered off what those interests are. And then the covenant must be shown to be no wider than is reasonably necessary for the protection of those interests. Reasonable necessity is to be assessed from perspective of a reasonable persons in the position of the parties as at the date of the contract, having regard to the contractual provisions as a whole and to the factual matrix to which the contract would then realistically have been expected to apply. So even if the covenant is to be held to be reasonable, the court will then finally decide as a matter of discretion if injunctive relief should be applied and granted. And making this decision, the court will have regard to among other things, the reasonableness then of the covenant as at trial. So the main thing that they'll look at is what is the meaning of the covenant and was it reasonable when the parties entered into it, but they will also consider as at the date the enforcement is sought as to whether the covenant is reasonable at that time. So if a restrictive covenant applying after employment is terminated is held to be unreasonable, then it's void and unenforceable. So we're going to look now at some of, sorry, I think just skip the one there, just going back one. So formalities and execution. In theory, a restrictive covenant is just another contractual term, and therefore there's no statutory rules or regulations about how it should be formed. There can be an implied term as much as any other in a contract. However, precision is paramount. And that's the main thing, and that's why it's so important to have restrictive covenants recorded and signed off, particularly given the costs of trying to enforce one of these covenants, given it has to be done through the High Court on an interim application. Therefore, it is extremely costly. For any interim application to the High Court, any law firm is likely to quote in the region of 20,000 for probably a day's hearing because of the amount of work and prep work that is put into it. So it's not something that can be done lightly. And you can just imagine that if that was done and the restriction was held to be unenforceable, the company is not going to be very happy, and they're going to be going back to the person who first drafted the restriction and will be considering their actions potentially against that party. So say restrictive covenants should always be documented expressly. And it's always in the employer's interest to obtain the employee's signed agreement, the restrictive covenant. So without this, it can be difficult to establish that all the elements of a binding contract are in place. So that's offer, acceptance, consideration, intention to create legal relations, and certainty. Those are the elements of a binding contract. So ideally, the restrictive covenants should be set out in the employment contract, but where they're set out in a separate document, this should be signed by the employee, and the wording should leave no doubt that the covenants form part of the terms of employment. So where the covenants do not form part of the terms of employment, so for example, where contained within the deferred remuneration scheme or in a share plan, it's important that the employee has actually signed off on a copy of the scheme rules. And the other, sometimes we've seen people put restrictive covenants in the staff handbook. That really doesn't work because staff handbooks are often stated to be non-contractual, and these covenants are contractual. And the other point can sometimes make that fall down is it's not always the case that staff handbooks are signed off and returned, particularly in a company with large numbers of people where there might be a staff handbook on the intranet, or there might be a staff handbook in the staff room, or there's a couple of hundred staff handbooks issued. Not every staff handbook is signed and returned, and therefore you wouldn't want to be relying on a covenant that's contained within a staff handbook. So now we're going to look at some of the actual covenants themselves. So non-solicitation covenant. So solicitation is where an ex-employee employee essentially approaches a customer or client of a former employer with a view to taking on their business. So it was looked at in Hydra versus Anastasi, and the High Court concluded that to solicit or entice meant to tempt, lure, persuade, or inveigle. Quite often then, what the employee will say is that they did not make the first contact to the customer, but it's not always the case that they have to make the first contact. So this was looked at in case of Croesus Financial Services versus Bradshaw. It was a High Court case, and the High Court held that solicitation can occur where the customer or client contacts the ex-employee first. It will also always be a degree of fact and degree. It will be relevant to assess who may contact first, but all the circumstances surrounding that contact must be considered. If an employer wants to prohibit any contact with customers without any argument about solicitation, it should consider a non-dealing covenant. However, a non-dealing covenant is harder to enforce, and we will look at non-dealing covenants as well. So, non-solicitation, the principle is that that's where the customer contacts the ex-employee. It doesn't always have to be the case, but generally, solicitation could also be where the customer contacts the ex-employee, but the ex-employee then replies to that initial approach. Because if the employee knows that it's restricted, really it should be saying to the customer, look, I can't discuss this with you at the present. I've got a restriction. It'll be 6 months before I can speak to you. So it is generally regarded as acceptable for an employee to inform clients and customers that they are leaving, and even to mention a contact address. However, there's a fine line between what's acceptable communication and what is unlawful solicitation. I think the case of Taylor, Stewart and Co. versus Croft is probably the best illustration of this point. So Croft was a partner in an accountancy firm, so he left to set up his own practice. And he then sent a letter to the clients on his new company letterhead, and he informed them of his departure. So this was him writing to his clients with his ex-employer, and he said he could be contacted as above. So this was found to be a breach of his obligations. And that's not surprising, but one thing is, in the judgment, the High Court did say that the letter would not have been a problem had it been limited to his first sentence. And Croft's first sentence was, this is to inform you that I left the partnership of Taylor, Stewart and Company on 18th of November 1984, full stop. So he'd left it at that, the court would have had no problem. However, he went on to say, I can be contacted as above. So essentially he was inviting the clients to contact him and giving his new contact details. And therefore this was held to be a breach of his restrictions. So at the very least, solicitation seems to require an invitation to transact business and intent to do so, whether that is express or implied. So implied means that you haven't expressly said, I want you to come and give me business. But if you are contacting someone saying, here's my contact details, that essentially is an invitation for them to contact you. And if you only know the person through business, why would you be asking them to contact you during your restriction? Obviously, there's a fine line there, because if you've known them in personal and you've socialized with them, that's a completely separate matter, and the court will have to take that into consideration. So non-direct and potential customers, we always think about solicitation that it's customers that the person has been dealing with, but quite often it's not. So if a clause is properly drafted, it can include customers that the ex-employee hadn't transacted business with but was aware of in the period before they had left, and that can be protected where the identity of the customers is not public knowledge but is known to the individual, or as to the general goodwill of the business. If this is the aim, the restriction should be limited to one of the following. So it should be restricted to the period that the identity of the customer will remain secret, the period that it will take for the individual's knowledge to go out of date, or the time until the goodwill ceases to attach to the individual and reverts to the employer. So a clause that attempts to extend the restriction to potential customers will obviously be harder to enforce. Such protection would only be appropriate where a business could show that building up a relationship with potential customers was a long and difficult process involving significant investment in time and money. And where I've seen that happen before is where, say, an employee has left an employer, but during their time with the employer, they were afforded, say, a budget of £20,000 a year for not for marketing, but more for socializing. So 20 grand, they take people to football games, they go out and take them for meals. And the employee's been spending this for, say, 5 years on a potentially lucrative potential customer, but never actually managed to get the business. So if you can see in that business has spent quite a lot of money on that potential customer. And if the employee then moves to his new employer and manages to hook that potential customer, that would potentially be enforceable, that we can enforce the covenant that they can't deal with that person. So Axiom Business Computers versus Frederick was a similar case to that scenario. The court upheld the covenant not to solicit potential customers, where the definition of customers included those potential customers with whom the employee on the employer's behalf had already had dealings, whether or not such dealings have resulted in the conclusion of a business transaction. So it is similar to the example I give in relation to hospitality spend. The covenant was upheld even in respect of potential customers because of the significant time and resources invested in negotiations to build up a relationship. In large companies where, particularly I suppose in our profession as in the legal profession, a lot of firms depend solely on insurance companies for their work, so you defend and road traffic accident claims, and they spend an obscene amount of money in taking the likes of Aviva to Ireland rugby games and taking a box, and they might never get Aviva's work because if you think about it, when Aviva gives them the work, it could be 10-20 million pound of legal fees over a number of years. So the idea of spending 50 grand a year on trying to get a 20 million pound contract is not out of the ordinary. So it happens, and that is, I suppose, why and when potential customers can be included within the scope of the restriction. So another one we look at is historic customer relations. So when seeking to prevent an employee contacting customers or former customers of an employee, it is usual to include in the covenant a backstop period. Never really want to use that word backstop, but it does apply here. So it's a period beyond which any customer contact is ignored. So quite often the way that's expressed in a restriction is that it says that the restriction only applies to customers that the employee had dealings with in the 12 months prior to termination. So ideally, those covenants refer to the employee being materially concerned to have had actual dealings with that person in the past 12 months. And what the thinking behind that is that it would be unreasonable to prevent the employee contacting former customers who have essentially long taken their custom elsewhere. So you can't protect your customers if they haven't used you for 12 months, because really if they haven't used you for 12 months, they're not your customer anymore. So Quilter Private Client Advisors versus Faulkner is a 2020 case, another High Court case. And in this case, the High Court refused to uphold covenants which sought to prevent a financial advisor from soliciting or supplying financial services to anyone who had been a client of the business during the 18 months prior to termination, and in respect of whom the advisor had been materially concerned. The 18-month backstop was held to be unreasonably long and would capture someone who had been ceased to be a customer nearly 18 months ago, and potentially who the employee had maybe only spoken to once, even within that 18 months. And significantly in this case, the court made note that the firm's clients actually had 6-month reviews. So a backstop really of 6 months would only have been what was reasonable, possibly 12 months at a stretch in the circumstances, because if they're doing 6 months reviews and you haven't heard from someone for 18 months, then they're not your customer anymore and you can't protect them. And that's essentially what happened here. Okay, so the next covenant we're going to look at is a non-dealing covenant. I mentioned it earlier in respect of a non-solicitation. So it's a wider version of a non-solicitation, because with non-solicitation, the difficulty is you got to prove that the ex-employee made contact or made an offer of in some respect to the customer. With a non-dealing clause, you don't. So a non-dealing clause effectively says you just cannot deal with this person in any capacity whatsoever for a period of 6 months, 12 months. So yeah, the type of the clear advantage is it removes the practical difficulty of proving solicitation. So the enforceability of a non-dealing covenant will depend on the interest being protected, and similar considerations as for the enforcement of non-solicitation covenants will generally apply. Enforcement may be more likely where the employer can establish a substantial personal connection between the employee and the relevant customers, and where the business environment is such that overt solicitation is not necessary for the employer to be exposed to significant loss of business. So in the case of London and Solent and Carrot and Partners versus Brooks, it was held that a non-dealing covenant could be enforced against a marine reinsurance broker at Lloyd's. And this was due to the fact that they had personal qualities that might lead the clients to gravitate towards them. It has also been held that where a non-dealing covenant is prima facie enforceable and the customer decides not to do any further business with the employer, but to remain loyal to the part employee, that covenant should be enforced. And that was the case of John Michael Design versus Cook. So the courts have also indicated that a non-dealing clause, when used in conjunction with a non-solicitation clause, can be justified in circumstances where it might be difficult to define and police a non-solicitation clause. So as I referred to earlier, they can be difficult to police, and where it proves impossible, the court may then be prepared to look at a non-dealing covenant. There will be occasionally be circumstances where the court will uphold a non-dealing covenant, even where there's little or no personal connection between the employee and the client. So the case that we have referred to there is Alan Jones LLP versus Johal. And in this case, the Court of Appeal upheld a non-dealing covenant, prohibiting a senior solicitor from dealing with all of the firm's clients after termination, even though she only dealt with relatively few clients during her time at the firm, so she wasn't there for very long. And the decision on this one, it harks back to what I said about the relevant time being when the actual restriction is entered into, because in this case, the solicitor had been recruited as a potential partner who would be introduced to a large proportion of the firm's client base. The fact that it didn't happen was irrelevant, and the restriction of the reasonableness of the restriction contained in the covenant had to be interpreted in accordance with the parties' contemplation at the time they entered into, and not in accordance to actually how matters turned out, because Johal never became a partner and never got access to all of the client base. But the covenant, when it was drafted, envisaged that she would have done, and that's why it was subsequently upheld. So the next covenant we look at is non-poaching. So non-poaching and non-employment covenants. So these covenants prevent a former employee from soliciting other employees that may have an impact on the employer's legitimate interest, which is the stability of its workforce. So this happens where one employee leaves, goes to a competitor, and goes back to their ex-employer to take members of their team. So we talked about team moves earlier. So in Hanover Insurance Brokers, the Court of Appeal refused to uphold a restriction seeking to prohibit the poaching of employees, irrespective of expertise or seniority, and including those who entered employment after the defendant had left. And we'll actually look at a case that gives a very good example of this. So the Court of Appeal has also held that an employer has a legitimate interest in maintaining a stable workforce and has acknowledged to be a highly competitive business. So Alliance Paper Group versus Presswich, the High Court granted an injunction to enforce a covenant, providing that a managing director would not employ or entice those who were employed in a senior capacity during the last 6 months of the service. So the key point there was that it only applied to people in a senior capacity. And in Hydra, as we referred to that case earlier, the High Court was prepared to enforce a non-poaching covenant that applied to all of the employees of a company. And that was because there were only 12 employees in the company. So they were happy in that sense because it was just small business that would apply across the board, because it would have detrimental effect to that business if it lost, say, half of those 12 people. So when drafting any non-poaching covenant, an employer must consider how long after termination the outgoing employee's influence over all employees will continue, and the scope and classes of employees over whom the influence will apply. So one of the key things is seniority. So the Donny Day case, which we referred to earlier as well, a 2-year restriction in relation to all of the employer's employees was unenforceable when contained in a shareholders agreement. So obviously Donny was a shareholder and was an employee. So they had a shareholders agreement, which the restriction applied to all employees. That was held to be unenforceable. But they also had an employment contract, and the employment contract applied to directors only and senior individuals. Therefore, that clause was held to be valid and enforceable. So a restriction on merely employing such people as opposed to soliciting them was again held unenforceable. Donny Day was then applied in White Digital Media Limited versus Weaver and another. The High Court refused to enforce a covenant which sought to prevent the employment, engagement, or appointment of the claimant's former employees. And in this case, the judge cited the public policy principle that third parties should not be restrained in their ability to seek employment elsewhere. So they looked at it from a different side. They looked at it, the fact that these employees want to move, they shouldn't be prevented from moving because one of their colleagues has a restriction in his covenant or his contract, particularly if they didn't have the same clause in their contract. So attempts are sometimes made to protect employers further by including an anti-team move clause. And that's referred to that earlier in relation to the solicitors departments. So the anti-team move clause limits the freedom of an employee to join former colleagues. So it's thought in many circumstances that such clauses will be struck out as being unreasonable, as they overly restrict and are contrary to public interest and not allowing people to move jobs. So non-competition covenants. So non-competition covenants, which prevent an employee joining a rival employer for the defined period after termination, has been traditionally harder to enforce than a non-solicitation restriction. And Lord Justice Underhill famously said it's the most powerful weapon in an employer's army is to stop someone from competing with them, because obviously it maintains their market share. The courts have recognized that other forms of protection, such as confidentiality restrictions and non-solicitation restrictive covenants, cannot always be effective in safeguarding a former employer's legitimate interests. So traditionally, a non-compete clause has been viewed by the courts as valid only if it's impossible or very difficult for an employer to police the more limited form of non-solicitation or non-dealing clauses. So a non-compete restriction, if non-solicitation and confidentiality is too difficult to enforce, the court will consider enforcing a non-compete restriction. So it's in certain circumstances. So first one is where it's not possible to give legitimate proprietary interest sufficient protection. So it's not possible to protect, the manufacturing process or the ingredients through implied and express terms. This was suggested in Printers and Finishers versus Holloway that it might be inevitable that the employee would use such information in any future employment. So restriction against counted activity is more realistic and easier to police. Number two, that the individual's influence over customers or suppliers is so great that the only effective protection is to ensure that they're not engaged in a competing business in any way. And this can happen when someone is the key sales account holder that's been dealing with a customer or customers for a extensive number of years. Just skip on there. Sorry, the slides have gone a bit off here. Yeah, I think that's where we were. So just some other examples then of some non-compete covenants as well. So in Thomas versus Farr and other, the Court of Appeal upheld the High Court's decision that a 12-month non-compete clause in a managing director's contract was enforceable. We spoke about that case earlier, and it was the fact that Mr. Thomas had confidential information that would be helpful to a competitor, particularly in relation to devising strategy and also charging rates. The reason that the non-compete was held to be reasonable is because it wasn't envisaged that Mr. Thomas would do the competing himself. It would be done, so the solicitation would be done by staff under him rather than him personally. In Maryland Financial Consultants Limited versus Cooper, the court upheld a 12-month non-compete restriction in an agreement between a financial advisor and his employer. Under a goodwill agreement, the financial advisor had been made a rather sizable payment to buy the customers he was bringing with him. And therefore, financial services is one place where it can be upheld. In Apex versus McDougall, the court upheld a 6-month non-compete restriction against 3 recruitment agents in the construction sector. The court found that the effect of the non-compete so drafted as to be limited to the areas where, so it was drafted in a matter that the non-compete was only in relation to the areas, so geographical areas that the employee was directly concerned. And so therefore it meant that they could still work, but they just couldn't work within construction recruitment, and therefore the restriction was in order and upheld. So Norbrook Laboratories, that is probably the key case in this area. So in this case, the High Court looked at the analysis of a non-compete restriction and when it can be reasonable to enforce it. The relevant restrictions sought to prevent the employee, a sales manager, from working for a period of 1 year after termination of her employment in a business whose products competed with that of her employer and with which she was concerned in the last 5 years of employment. That's an important part of this case. The court ultimately declined to enforce the restriction. However, the guidance it gave was the significant. The reason it said authority in the area is that although the restriction wasn't upheld, that the judge in their decision gave a really good guidance on the various aspects of a non-compete restriction. So the court rejected the employee's argument that any confidential information about prices and discounts had a limited shelf life and so would lose its confidential nature before the 1 year period expired. So the court found that the usefulness of such information to a competitor was not limited to 6 months. So the duration of the restraint of trade of 1 year was reasonable. The court then looked, and this was quite a surprising development. The court looked at the employee's interview notes with her new employer, Pfizer. So the notes revealed that the employee had disclosed some information about Norbrook in her interview, but she had said in the interview that she possibly should not have mentioned it. And this remark was a clear indication that she knew that the information discussed with Pfizer was confidential. It was reasonable for a non-compete restriction not to be confined to restraining the employee from working in the same capacity that she worked for Norbrook sales, i.e. The fact that she'd given the information in the interview showed that it didn't really matter which role she was employed in with Pfizer, that she was happy to give out confidential information about Norbrook, which would be valuable to the business in many different departments. So the 1 year period was not unreasonable. And the all reason for that was that Norbrook's customers actually entered into 1 year contracts themselves. So Norbrook would be vulnerable at the time of renewal, or up to the time of renewal. The fact that the employee in this case was not on a significant salary was not taken into account in relation to the restriction. So as I said at the beginning, the significant part was the reference to the products to which the employee had been concerned with over the last 5 years of employment. And that is essentially where the clause fell down. So the restriction for 5 years, this could mean anything from anything that she'd been really materially involved in, but also could have a tenuous connection. And the ambiguity in this made the definition unsuitable for the reasonable protection of customer connections. And the court also found that a lot of the products that was protected were actually Norbrook's products, and therefore Pfizer couldn't possibly have sold those products in any event. So definitely a case, if you're looking at in this non-compete clauses, definitely one that is worth looking at that case as a whole, if you have any time to read it. So geographical restrictions are another thing you'll also often see in restrictive covenants. So they prevent the employee acting in certain geographical areas post termination. These are becoming less common because, particularly with the pandemic as well, that you could be based here in Northern Ireland, but you could be doing work in England, you could be doing work anywhere. Work has become remote. So those clauses need to be reviewed in light of that. And also they can be quite tricky in companies that are in areas such as the City of London, where a 1 kilometre restriction can cause all sorts of problems for an employee, because a lot of, say, financial services in the City of London are within 1 kilometre of each other. So it would essentially restrict, say, a broker from working for any other brokerage for a year because they're all within the 1 kilometre. Similarly, like it maybe would apply in Wall Street. So in assessing a geographical restriction enforceability, we look at the actual relationship between an interest to protect it and the geographical area, the activities of the employee, and the size, nature, and density of the population of that area, i.e. The City of London. The Office Angels case was one that related to the City of London, and again, that was unenforceable because 3 kilometres took out too wide of an area. And in addition, in that case, the Court of Appeal found that there was no need for a territorial restriction because the clients in that case came from anywhere. It didn't really matter. So the geographical restriction was not upheld. So one case that probably illustrates the point quite well is Quilter Private Client Advisors versus Faulkner. In this case, the court refused at full trial to uphold a non-compete in a financial advisor's contract that sought to prevent her from competing with her employer, Quilter, for 9 months after termination. There were carve-outs which allowed her to be engaged in geographical areas where Quilter did not operate, or in providing services with which she had not been involved in her last 12 months with Quilter. The problem was that Quilter had offices throughout the UK, and so the clause essentially operated as a UK-wide non-compete. And the court noted that it was not legitimate to prevent competition per se, because if you think about it, Quilter, the client, the employee was actually based in Carlisle, so really it should only have applied to Quilter's Carlisle office, because the client didn't have any knowledge of clients in, say, or customers in, say, Manchester or London, so it shouldn't have really restricted her from going to work in London, but it did, because Quilter had offices in London. So again, the covenant was too wide and then held to be unenforceable. So the duration of restrictive covenants, you'll also often see that they'll last for, say, 9 months or 12 months post-termination. And I think the key thing here is they look at really how long will it take the employer to have a replacement, step into that employee's shoes, and establish a connection and a relationship with the customers that ex-employee used to work with. And that's what you've got to keep in mind. If that can be done quite easily, and the employee that's leaving didn't really have a great relationship with the clients or wasn't really there that long, then a shorter restriction is in order. But where they've been there a long time, where they socialize with the clients, etc., then a longer restriction, because it will take someone around 12 months probably to try and get themselves in with that customer and re-establish commercial relations on the same basis. So I think they've covered that with one, and you'll see the quote from WRN. In the case of an employee employed to sell, the purpose of the period for which the restrictive covenant is in operation is to enable the employer to have an opportunity to replace the employee, for the replacement employee to have an opportunity to seek to forge for himself or herself the contacts which the previous employee enjoyed for the benefit of the employer. Okay. So the other thing to look at is the turnover of staff and the length of the employees' notice periods. Where turnover is high and employees are often seek to leave in short notice, it may be harder to justify. Just give me a wee second. I might pop my charger in here. I'll get cut off completely. There we go. Okay. Sorry, I just lost the slides there. So the duration, so look at the industry standard, any geographical restrictions that apply as well. So, if there's geographical restrictions, then, and they're quite wide, then a shorter duration of covenant will be in order. So as with all restrictions, they'll also look at the legitimate interest that's been allegedly protected. So one thing I want to point out, because I know there's some HR managers, etc., on the talk today as well, is that restrictive covenants and repudiatory breaches. So repudiatory breach is where an employer breaches the employee's contract of employment, and that's significant for the likes of a constructive dismissal case. So if an employee has been wrongfully dismissed or constructively dismissed, then the post-termination restrictions fall away. So you can't rely on a contract that you've already breached. And in a constructive dismissal claim, an employee will say, you've breached my contract, I'm no longer bound by the terms. And therefore, if that was correct, they would be entitled to compete without any restriction whatsoever. So it's always worth looking out. And if you're ever advising an employee in these circumstances, senior one, and they are under, they do feel they've been treated poorly, it's quite often better for that person to not resign and give notice, but to resign, claim constructive dismissal, and they will then be able to move on without any restrictions. So just one to bear in mind. So one thing I just wanted to touch on as well, I appreciate we might be tight for time here at the minute, so I might need to gloss over that, but it's something to bear in mind. Challenges presented by social media, and that just refers to the likes of LinkedIn profiles, Twitter profiles, Facebook profiles, and where that now has become a situation where employees own and operate those sites. And it's a breakdown of really who owns the information. Is it owned by the employer? Is it owned by the employee? And another thing as well that you might want to have a look at is in relation to people who change their LinkedIn profile when they leave. So if an employee is leaving, it may be that we want to limit what they can say on social media, and also a change in the profile, because a change on LinkedIn profile is good enough to let a customer know that someone has left one business and joined another, because they get a notification, they say they've changed jobs. So just remedies before we wrap up. And as I said, it was always going to be impossible to cover this in an hour, and it's definitely been proven here. The remedies, so if you're looking to enforce a restrictive covenant, they are enforced by what's called equitable remedies, and the main is an injunction. So the first thing is you go to court and you say, we want this employee to be prevented from doing this, and the court will give an injunction, which basically says the employee that the restriction is enforceable, and the employee must immediately cease and desist from doing anything to contact any customers, deal with any customers, compete, whatever the restriction is. And that's done by a prohibitory injunction to stop. And a springboard injunction can also be used, which stops the new employer from basically getting a head start in the market. And then the cases are heard by final injunctions, and one way these are often resolved is when you issue proceedings that the defendant, so the employee, gives undertakings that he will not breach the restriction. One of the other good tactical things is if you're in this situation that you add the new employer as a party. So you say that the new employer hasn't just to breach a contract. You say, look, you've conspired conspired with the employee, and you have manufactured this to get them to come to you, and you're in the knowledge of what the restrictions are, and you have let them compete, and therefore you're also liable as an adjustment of a breach of contract. The conspiracy angle relates more to team moves and conspiracy between employees to all move together. Again, that can be enforced through the courts. So you'd be glad to know probably this is the last slide. The future, not really relevant or specific to Northern Ireland, but in the UK, there was a government consultation quite recently whereby views were sought on proposals to, one, make non-compete clauses in contracts enforceable only where the employer pays the employee for that period of that period of restriction. And then the second one is to ban non-compete clauses altogether. And that was really coming out of the back of COVID and as well the economic impact. It was just really try and stop this anti-competition practices really. And it closed on 26th of February 2021, and to my knowledge, no one has heard anything about it yet. So it's obviously in the back burner, but if it was implied or carried out in Great Britain, no doubt that the executive in Northern Ireland have to look at doing something similar. So sorry for overrunning there, but as you can appreciate, it is a very difficult topic to try and cover in the time allotted. I'm going to pass over to Danielle now. If there has been any questions, Danielle's going to pick those up, and I will try my best to cover off any questions you've had.
I'd just like to say thank you, Gareth, on behalf of Derry and Strabane Council for delivering the session today. I think everybody that has been able to join us will agree that, you know, while it's a very complex subject, you really gave us a lot of food for thought there in terms of managing these issues. So thank you very much for that. Folks, if there's any questions at all, please just either use the Q&A button at the bottom or the chat, either or. I'm conscious of time, so if we don't have any questions, that's fine as well. And if anybody does have any questions following the session, we can always pass them on to Gareth. I'm sure you wouldn't mind that, Gareth.
Not at all. And I can drop me an email. I'm happy enough to. And I can say I have some more detailed slides as well that I was using. So if they want, once those pinged across, I can send them across as well.
Great, thank you very much. It doesn't look like we have any questions coming up here for now. So all I can say is thank you, Gareth. Thanks to everybody who joined the session today. I'm sure you'll agree it was very informative. We will be getting this up online as well. So if there's anybody who hasn't been able to join or had to potentially leave a bit earlier, you will be able to catch up on the session online as well. So thank you very much.
All the best. Thank you.
Bye-bye. Thanks, Gareth. Bye.